Okay, we have Beef Cattle Group versus Winfrey, February 2000. Oprah Winfrey's battle with the Texas ranchers over comments made on her show about mad cow disease become a headline-grabbing defamation case. Given Winfrey's incredible popularity, the case attracted worldwide attention. It was such a big case because of who Oprah was and also because it dealt with such an important matter of public concern, food safety. Legal Defense Director Greg Leslie told us. In March 1996, British health authorities announced that the scientists had linked the consumption of beef with bovine spongiform encephalopathy, BSE, or mad cow disease. This postulated link between the consumption of beef and brain disease caused great panic in Britain. Panic spread to America via one of America's most popular personalities, Oprah Winfrey. 1 month later, the Oprah Winfrey Show aired its Dangerous Food episode, featuring comments from vegetarian activist Howard Lyman, who believed that mad cow disease could cause an epidemic in America bigger than AIDS. On the Oprah Show, she said, Oprah quoted, I'm stopped cold from eating another burger. The show apparently had a devastating impact on cattle prices and sales. On May 28, 1996, Paul Engler of Cactus Feeders Incorporated sued Winfrey in state court on several theories, including claims under the state's food disparagement or veggie-level law called the Texas False Disparagement of Perishable Foods Products Act, and several common law tort theories. These included business disparagement, defamation, and negligence. The case was later moved to federal court and consolidated with a separate action filed by the Texas Beef Group. The case proceeded to a jury. Before submitting the case to the jury, U.S. District Judge Mary Lou Robinson dismissed the claims under the food disparagement statute. The district court judge questioned the applicability of the statute to live fed cattle. Robinson also rejected the plaintiff's defamation claims because they could not meet the of and concerning requirement. None of the plaintiffs were mentioned by name in the show, and it stipulated this program did not even mention by the name the state of Texas, Texas Panhandle, or West Texas. Robinson submitted also that the plaintiff's business disparagement claim to the jury. In February 1998, the jury rejected the plaintiff's claims. On appeal, the third judge panel of the 5th U.S. Circuit Court of Appeals ruled in February of 2000 the Texas Beef Group versus Winfrey that the lower court decision should stand. Plaintiffs challenged the district court's dismissal of their claim under the False Disparagement of Perishable Food Acts. Passed in 1995, that law provides that a person can be held liable for damages suffered by the producers of a quote-unquote perishable food product if that person knowingly disseminates false information to the public stating or implying that the producer's product is not safe for public consumption. The lower court has determined that the live cattle did not constitute a perishable food product and that alternatively the defendants did not knowingly disseminate false information about beef. In February of 2000, a three-judge panel of the 5th U.S. Circuit Court of Appeals also ruled in favor of Oprah in Engler versus Winfrey. The appeals court determined that even though the Oprah Winfrey Show may have melodramatized the mad cow disease scare, the show and its guests did not defame the beef producers. Exaggeration does not equal defamation, the panel wrote, citing an earlier Fifth Circuit decision. Lyman's opinions, though strongly stated, were based on truthful, established fact and are not actionable under the First Amendment, the court wrote. Stripped to its essentials, the cattleman's complaint is that the Dangerous Food Show did not present the mad cow issue in the light most favorable in United States beef. Plaintiffs contended that the district court judge improperly instructed the jury on the business disparagement claim. They argued that the instruction unnecessarily required the jury to determine that false statements were made specifically regarding their cattle. They also argued that the trial judge erred by requiring the jury to find that false statements were made of and concerning the cattle to the plaintiffs as opposed to the more general of and concerning beef. However, the appeals court determined that counsels for the plaintiffs did not preserve these issues by objecting to the alleged errors when they were made. Judge Edith Jones wrote a concurring opinion. While she agreed and joined in the court's opinion with regard to business disparagement issues, she wrote separately because she believed the False Disparagement of Perishable Food Products Act did not apply to the cattle. The purpose of the statute's definition is to distinguish perishable from processed food products and do not eliminate protection for some of those farmers and ranchers whom the statute was intended. Many legal experts hope that, particularly to the high visibility of the case and its famous defendant, the lawsuit will serve as a test case for the unconstitutionality of food disparagement statutes. More than a dozen states have similar veggie-level laws, and many of them relax the burden of proof imposed on traditional defamation plaintiffs. The Fifth Circuit even acknowledged this, writing, "The cattlemen's complaints regarding the dangerous food broadcast of the Oprah Winfrey Show represented one of the first opportunities to interpret the food disparagement statute. The insufficiency of the cattlemen's evidence, however, renders unnecessary a complete inquiry to the Act's scope." The plaintiffs petitioned for an en banc review, but were denied in April 2000. The impact this had is while the court failed to strike down the Texas food level law, the decision still had a discernible impact on the public's understanding of defamation in the First Amendment. It certainly seems to have stopped the enthusiasm for product disparagement statutes, Leslie said. "I think the decision taught the public a lot about defamation law and the First Amendment in general. It taught the public that even if a statement is wrong, there is an important reason to allow even false statements to be made on the public's issues. There must be breathing space for the First Amendment." Perhaps what most summed it up is what Oprah said when asked about it. She said, "Free speech rocks."